Youth Criminal Justice, Youth Court. Many young people who are charged with a crime are unfamiliar with the court process. This video gives a basic overview of what a young person should expect after they are charged with a crime and must attend youth court. When a young person is charged with a crime, the police will submit the case to a lawyer working for the prosecution. In Canada, the prosecutor is often called the Crown because he or she represents Canada's head of state, the Queen. The Crown will review the case and decide whether it is appropriate for court proceedings, or should instead be resolved outside of court through extrajudicial measures. Some criminal cases involving youth do not make it to court because the young person agrees to other sanctions, such as community work. If the Crown decides the case should go to court, then the young person will receive a notice in the mail telling them to attend court on a certain date. There are several people in the courtroom who play important roles in the justice system. The most important person in the room is the judge. It is customary for everyone to stand when the judge enters the courtroom or gets up to leave. For some types of hearings, such as a bail hearing, the person sitting at the top of the court may be a justice of the peace instead of a judge. In front of the judge is a person called the registrar, who handles all the paperwork of the courtroom. There is also the court reporter, who records everything that is said in court. Finally, there are the lawyers, the Crown, and the defense. The young person's first court appearance may involve several things. The Crown may be ready to give a copy of the evidence to the defense. This is called disclosure. The defense is entitled to a copy of all the evidence in the Crown's possession. If the disclosure is not ready yet, the first court appearance may involve nothing more than setting a date for the next appearance. After the defense has received the disclosure of evidence and has had time to review it, the next step is called the plea hearing. At the plea hearing, the registrar will read the allegations that the young person has been charged with. The court will then ask the young person whether they want to plead guilty or not guilty. If the young person pleads not guilty, it means they do not admit the charges that have just been read in court. The Crown then has to prove the charges at a trial. If the young person pleads guilty, it means that they admit that they committed the crime. That means the Crown no longer has to prove the charges. There will therefore not be a trial. Usually, the Crown will try and negotiate a deal with the defense lawyer, where if the young person pleads guilty, the Crown will recommend a lighter sentence. This is called a plea bargain. It is important to know, however, that even if the young person agrees to plead guilty, the court does not have to follow the Crown's recommendation of a lighter sentence. If the young person pleads not guilty, then the next step is the trial. At the trial, the Crown must prove that the young person committed the crime beyond a reasonable doubt. Both the Crown and the defense will have an opportunity to bring forth evidence. At the end of the trial, the judge will decide whether he or she believes that the young person is guilty beyond a reasonable doubt, based on the evidence heard in court. After the young person has been found guilty, the judge will decide on the sentence. A sentence is a court-ordered penalty for committing the crime. The judge can decide from many different sentences, including reprimand, reprimanding the young person in the courtroom, discharge, letting the young person go, with or without conditions, fine, ordering the young person to pay a fine, community service or counseling, ordering the young person to do community service, counseling, or another social program, prohibition order, ordering that the young person be prohibited from doing some activity, probation order, ordering the young person to check in with a probation officer from time to time, custody and supervision sentence. The harshest type of sentence is custody and supervision, where the young person is placed in a detention center for a period of time. Sentences for young people in youth court are typically more lenient than if the crime had been committed by an adult. In rare cases, the court may order an adult sentence if the circumstances of the crime are so serious that a youth sentence is not appropriate. For more information about youth criminal justice and the court system, please visit the website for Canada's Department of Justice at www.justice.gc.ca. To find out if you qualify for free legal aid, contact your province's legal aid organization or local legal aid office.